He got it all right. You think I'm really going to tell the guy who argued and won Calais that he didn't understand what he was arguing?
Okay.
Sorry, no, I'm totally respectful. Yeah, obviously, I think he's got a good handle on it.
I understand that, Mr. Cox. I don't mean to be rude, the importance of precedent and all that. But didn't the Supreme Court say, except in very narrow circumstances, you just can't use race to help a person, and you can't use race to harm a person? And that includes in drawing congressional districts.
Welcome back to Freedom Forge, the channel where we break down the biggest political battles shaping America today from a patriotic, America First perspective. Before we dive in, make sure you hit that like button, subscribe to the channel, and turn on notifications so you never miss an important discussion about the issues affecting our country. Today, we're looking at a Senate hearing that centered on one of the most controversial issues in modern American politics: the role of race in government decision-making. Specifically, senators and legal experts debated Supreme Court rulings involving race-based congressional districting, voting rights law, and whether race should continue to be considered when governments draw electoral maps or implement remedies for past discrimination.
Thank you, Mr. Chairman. Mr. Grime, am I saying your name right?
You are, Senator.
You argued the Calais case?
I did.
Okay. I'm going to tell you my understanding of the case. And then, Mr. Cox, I'm going to ask you to tell me if Mr. Grime got it right. And Mr. Chamberlain, you can chime in if you would like. Are you familiar, Mr. Grime, with the Students for Fair Admissions case?
I am.
Okay, that's the case recently where the Supreme Court said you can't use race in college admissions. Now, here's what I heard the Supreme Court say in that case. I heard the Supreme Court say, look, colleges, we're not going to get into the admissions business. That's your business. We're just telling you you can't use race as a factor to admit anybody. Is that your understanding of the case?
Basically, yes. And they did a whole 14th Amendment.
Don't try to muddy the water to make it look deep, guys. I know you're all smart. I'm just trying to get to the bottom line. Am I wrong or right?
You're right.
Okay. Now, the way I read Calais is the Supreme Court is saying, look, first of all, these are political questions. And we're not going to tell the states how to draw congressional districts. We don't want to be in that business. That's a political question. We're just saying you can't use race as a factor. Is that what they did in Calais, or am I misunderstanding it?
That's basically it. You can use it to remedy, past discrimination that you've proven. But that wasn't the case in the Calais case. The other side didn't prove it.
Well, but once again, you're muddying that water, man. Did the court, or did it not, say that you can't use race to draw a congressional district?
In most cases, you can't unless the state, the person defending the map, shows that they had to use it because there was a showing of immediately past intentional discrimination, that they had to use race to unwind.
Okay.
Yeah.
Tell me whether he got it right, Mr. Cox.
Senator, quite frankly, the defense of the Calais case is such a tortured exercise. It's
Mr.
difficult.
Cox, I don't want to hear.
So I'm going to tell you what
I want you to answer
SFFA, how
my question.
SFFA applies to Calais.
Did he get it right, or
He did not get it right. Okay. So in under application to discuss Calais, you have to really discuss what happened in the case that created the district that was challenged in Calais. That was Robinson.
All right.
The court required the state of Louisiana to redraw its plans pursuant to its findings of a Section 2 violation.
Look, I don't
That's
want to have
what
a fight.
justified the creation of the plan.
I don't want to have a fight. Can you just tell me, and you're smart, and I don't want to make this more complicated than it is. Tell me what he got right or wrong.
I'm telling you, what he got wrong was ignoring...
No, you're speaking like a lawyer, okay? And I'm tired of, I've listened to you gentlemen, okay? Let's just get down to it. Mr. Chamberlain, tell me what Mr. Graham got right or wrong.
He got it all right. You think I'm really going to tell the guy who argued and won Calais that he didn't understand what he was arguing?
Okay.
Sorry, no, I'm totally respectful. Yeah, obviously, I think he's got a good handle on it.
I understand that, Mr. Cox, I don't mean to be rude, the importance of precedent and all that, but didn't the Supreme Court say, except in very narrow circumstances, you just can't use race to help a person, and you can't use race to harm a person, and that includes in drawing congressional districts?
In answering that question, I'm going to tell you that the Robinson Court, which gave rise to the district that was challenged in Calais, said that there was a violation of the Voting Rights Act, that it was required to draw a district or draw a redistricting plan that satisfied the Voting Rights Act, that allowed African Americans to elect candidates of choice.
You don't want to answer
that's
my
what was
question,
challenged.
do you, Mr. Cox?
I'm answering your question.
No, you're not.
Maybe an answer that you don't like or my colleagues don't.
No,
like,
you're not.
But I'm answering
you're
your
not.
question.
You're giving us another lecture, and this is not a common law class. Tell me in simple terms, is that not what the court said?
The court said a lot of things that were inaccurate. So that court said you can't use race at all in drawing plans. We disagree with that. But what the court really did was say that you can prove race you can prove there's intentional discrimination, which is in violation of this Congress's intent. It also sprinkled partisanship as a defense for any challenge to any challenge under Section 2.
All right, well, I'm about out of time. I can see no disrespect, Mr. Cox, but you're not answering any of my questions. And I know you're disappointed in the decision, but let me put it another way. Do you think race should be used to help a person?
I don't understand that question. Race should be used to
a
help
person? Do you think race should be used to help a person?
I believe that if there is a racial violation of the law, that race discrimination, I believe a remedy that's race conscious can be required, yes.
Do you think race should be used to harm a person?
I don't really understand what that question
No, I didn't think you would. Mr. Chamberlain, do you think it's fair in America to use race to help a person at the expense of other races?
No.
Do you think it's fair in America to use race to hurt another person?
No.
How about you, Mr. Graham?
Absolutely not. Race should not be used to help or hurt an individual.
And no disrespect to Mr. Cox. He's very bright. I can see that. And I've been where you've been. You know, when you get in front of a court of appeal and you're losing, you know, you want to kind of obfuscate. I get it. But that to me is what the court's saying here in all these cases. We're not going to try to run your business. Not in the college admissions, not in drawn districts. But you can't use race. Period. End of discussion. And I think that's what the Constitution says and what most Americans support. I know you're disappointed, Mr. Cox.
I'm not disappointed. I'm outraged.
But that's what the Constitution says.
Well, can I add one more thing that's
Sure.
not quite exactly addressing what you asked? I do think there's a role for a co-equal branch of government, Congress, to make its own determination regarding how it wants its laws enforced. And I would urge this Congress to reconsider Calais in that light.
Yeah, but you and I are both aware that the United States Supreme Court has full authority to pass on the constitutionality of a statute. Come on, you know that. I'm sorry, Mr. Chairman.
If Mobile versus Bolden is any example of what can and can't happen, this Congress can take a look at Calais and say, actually, you got it wrong. And you actually didn't interpret what we intended in 1982 correctly.
The problem with your argument is, I don't think race should be used to help a person because of his race. And I don't think race should be used to harm a person because of his or her race. And I think that's what most Americans believe. And if you don't believe the opposite, and you clearly do, this is America. You can believe what you want. But the Supreme Court is deciding these cases.
I hear you.
Saying race is off the table.
I hear you. And I believe as a civil rights lawyer that if you find a violation based on race, you need to craft a remedy that addresses that.
Sure.
Senator Whitehouse.
I'm sorry.
This hearing quickly became a fascinating clash between two very different visions of America. On one side, you had those who believe race-conscious policies are sometimes necessary to address past discrimination. On the other side, you had lawmakers arguing that the Constitution requires equal treatment under the law regardless of race. And if you ask me, that's where the most important part of this entire discussion lies. One of the strongest moments in this hearing came when Senator John Kennedy tried repeatedly to cut through the legal jargon and get simple answers to straightforward questions. Whether you agree with him or not, you have to admit that many Americans watching these hearings often feel frustrated when experts answer direct questions with lengthy legal explanations. Kennedy kept bringing the discussion back to a simple principle. He referenced recent Supreme Court decisions, including the Students for Fair Admissions case, where the court ruled against the use of race in college admissions. His argument was straightforward. He believes the court is increasingly saying that race should not be used as a deciding factor by government institutions. What stood out to me was how determined Kennedy was to get beyond the complicated legal language. Time and again, he asked variations of the same question. Did the court say race should not be used? Did the court say race should be taken off the table? Can government treat people differently because of race? These are questions that resonate with ordinary Americans because they're not buried in legal theory. They're rooted in basic ideas of fairness. One witness attempted to explain the complexities of voting rights law and prior court decisions that led to the disputed congressional districts. And to be fair, there are legal nuances involved. There are decades of court rulings, Voting Rights Act provisions, and constitutional questions that lawyers spend entire careers studying. But from a perspective of many Americans, the issue feels much simpler. If two citizens are standing side by side, should the government treat them differently because of their race? That's the question that keeps coming up. The most dramatic exchange happened when Kennedy began asking witnesses whether race should ever be used to help a person or hurt a person. Notice how direct those questions were. Do you think race should be used to help a person? Do you think race should be used to hurt a person? These aren't complicated constitutional hypotheticals. They're moral questions. One witness argued that race-conscious remedies can sometimes be necessary when there has been proven racial discrimination. That's a position many civil rights advocates have held for decades. Their argument is that if discrimination occurred because of race, then the remedy may need to consider race as well. But another witness took a very different position. He said race should not be used to help or hurt an individual. Personally, I think that's the position most Americans instinctively support. As a conservative patriot, I believe the promise of America is that every citizen stands equal before the law. Not equal outcomes, not equal representation percentages, equal treatment. The 14th Amendment promises equal protection under the law. It doesn't promise that government officials get to sort citizens into racial categories forever in pursuit of social engineering. Now, that doesn't mean discrimination never existed. Of course it did. America's history contains painful chapters that nobody should ignore. But the question before us today isn't whether discrimination happened decades ago. The question is whether government should continue making decisions based on race in the present. That's where the disagreement becomes intense. Supporters of race-conscious policies argue that ignoring race can sometimes preserve inequalities that already exist. They believe government intervention remains necessary. Opponents argue that the only way to truly move beyond racial division is to stop using race altogether. I find myself agreeing with the second argument. How can we ever achieve a society where race doesn't matter if government itself keeps making race matter? How can Americans stop seeing each other through racial categories when institutions continue organizing policies around those same categories? These are questions that deserve serious consideration. Another important moment came when one witness openly admitted he was outraged by the Supreme Court's direction on these issues. That statement revealed just how significant these cases have become. This isn't simply an academic legal debate. It's a battle over competing visions of constitutional interpretation. One side sees race-conscious policies as necessary tools for achieving justice. The other sees those same policies as violations of equal treatment. The Supreme Court appears increasingly sympathetic to the latter view. And that's why hearings like this matter. What we're witnessing is not just a disagreement over one congressional district or one legal doctrine. We're witnessing a broader national debate about whether America should move toward a colorblind legal system or continue allowing race-based considerations under certain circumstances. From my perspective, the Constitution points us toward equal treatment. Not because we're pretending history didn't happen. Not because we're ignoring injustice. But because the best way to guarantee fairness in the future is to stop dividing citizens according to race in the first place. The more government categorizes Americans by race, the harder it becomes to build the unified national identity that this country desperately needs. America is strongest when citizens see themselves first as Americans, not as racial groups competing for political advantages, not as demographic categories fighting over representation. Americans. That idea may sound old-fashioned in today's political climate, but I believe it's exactly what many people across the country are longing to hear. At the end of the day, this hearing exposed a fundamental divide in American politics. One vision believes race-conscious policies remain necessary to achieve justice. The other believes justice requires government neutrality and equal treatment regardless of race. The debate is far from over. The courts will continue hearing these cases. Congress will continue debating them. Advocacy groups will continue fighting over them. But for many Americans watching at home, the central question remains surprisingly simple. Should race be used by government to help one person or disadvantage another? Based on this hearing, that's the question that refuses to go away. And judging by recent Supreme Court decisions, it's a question that may shape American law for years to come. Thanks for watching Freedom Forge. If you enjoyed this breakdown, make sure you hit the like button, subscribe to the channel, and share this video with fellow patriots who care about the future of equal justice under the law. Let me know your thoughts in the comments below. Should race ever play a role in government decisions? Or should America move toward a completely colorblind legal system? I look forward to reading your comments, and I'll see you in the next video.